So we'll talk about U.S. tariffs today and a quick recap of what's happening and your take from San Francisco, California. And I wanted to start from a bit, the laying a general overview. So the Supreme Court decision on February 20 held that the IEEPA tariffs are illegal. What does that mean? And for companies who have paid tariffs?
Thanks, Roberto, and it's great to see you. This is really a hot topic amongst our clients, and I think just internationally, because you've got importers from all over the world, really, who's paid substantial amount of tariffs in the United States. And the companies who've paid these tariffs, they have been ruled illegal, as you said, by the Supreme Court on February 20th. Now, that is sort of the straightforward, easy summary of what's happened is those tariffs are illegal, and the court has also said that companies should be refunded. Unfortunately, the analysis on whether companies will be refunded is much, much more complex than that. While it's a simple conclusion, it's a complex analysis that changes actually daily. We're getting news from the Court of International Trade, who is the court that's dealing entirely with the refunds. And it had a March 4th order, basically a very broad order saying that all companies are entitled to a refund on IEEPA tariffs. And then since that order, that same judge has actually narrowed that order about 3 or 4 times. And so we don't know what those refunds are really going to look like. And the problem is, while we know that those tariffs are illegal, I'm not sure that if companies take the sort of standard wait and see administrative route, if they will ever be refunded on all of their tariffs, and when they will be refunded. The government is trying to simplify it and say, we're putting a program in place, you'll be able to sign up, and once you sign up, you'll get your refunds. That's not at all what's happening. In fact, we've read various declarations by the government, by the CBP, telling us about that system. And that system is highly complex. It's not yet finished. It's a software, essentially, that may or may not crash immediately. And it's really a 3-step system. And there's going to be questions as to different categories of tariffs and what the status of those tariffs are and if they should be refunded. And so generally, while, of course, it's great news that these companies should and will be refunded, hopefully, those tariffs, the bad news is that we are skeptical on how and when that will happen. And so we've been advising clients on really what to do and how to protect your rights in this regard.
Okay. Yeah. What's the expected number of, let's say, applications for refund? Do you have an estimation of the volume of litigation that is coming to the court?
Yeah, I mean, we're talking over, I think, $100 billion in tariffs. I can't remember the exact amount. So that's significant. I mean, you've got companies like FedEx who've, of course, filed a claim in front of the Court of International Trade with a $2 billion claim itself, right? So you've got huge claims, and then you've got companies with much smaller claims. I think a lot of companies, mid-sized companies, for example, have claims in, the $4 million range, $4 to $8 million range. I think smaller companies, of course, have smaller claims, but you can see the magnitude of these claims. And in terms of sort of the number of cases that have already been filed in front of the Court of International Trade, I think it's over 3,000. And yeah, it's a significant number. And that tells us that customers are very concerned as to whether or not they are going to be refunded, and that, the advice, the legal counsel is file a claim. If you have a significant claim, I would say, generally $1 million and above in tariffs, it's worthwhile to file a claim in the front of the Court of International Trade, because do you want to gamble on $1 million? It's just not worth it.
Yeah. And are all entries pursuant to IEEPA eligible for refunds?
It's a good question, because the answer is we don't know, which is usually always the answer. Theoretically, yes. The Supreme Court has said IEEPA tariffs are illegal. So that ruling should mean that all entries with IEEPA tariffs attached to it, and that includes reciprocal tariffs, there's a number of categories in there, should also be refunded. Now, really what it is that there are 3 categories of entries. And those 3 categories are sort of the entry that the importer makes, and those are estimated, okay? They pay those tariffs, they're estimated. And then the government, the CBP, has 314 days to, at most, to liquidate those entries. Really, all they're doing is saying, this is a correct amount you paid, or this is incorrect and you owe this much. And then once those entries are liquidated, then the company, the importer, has 180 days from that date of liquidation to protest and say, hey, government, you got this wrong, and here's why. Usually it's an administrative or clerical error. That's what the protest is for. If the company does not protest, then that liquidation becomes final. Okay, so those are final liquidated tariffs. The problem with final liquidated entries is that there is no mechanism really to appeal or change that, because they are final. So in terms of the first 2 categories of tariffs, the court has already said that if they're not liquidated, they must be refunded. If they are liquidated and not final, they must be reliquidated without the inclusion of the IEEPA tariffs. If they're final, the court has been somewhat silent on those categories. Also, the middle category of liquidated tariffs, it was sort of believed that because the court has already said they should be reliquidated, that there's nothing that the importers really needed to do, that they were maybe automatically going to be reliquidated through this ACE portal. Actually, last week, the court came out and instructed, sort of softly, but instructed importers to pursue the mechanisms available to them. And what it really did was cited to something that said you should protest those entries. And that means you've got to go in entry by entry, fill out a form or some other way, and protest those entries that have been liquidated that are not yet final. And so now we're actually instructing our clients to go ahead and protest all liquidated entries. What that will do ultimately is it's unlikely the CBP is going to make a decision on those. They're going to get hundreds of thousands of requests. But hopefully what it will do will preserve the importer's right to then seek litigation in front of the Court of International Trade also on those entries.
Okay, so you recommend to do this preliminary step, let's call it administrative step, and then file suit at the Court of International Trade. What's the rationale behind it? So why file suit anyway, even if you have already pursued the administrative route?
Yeah, I mean, it's a great question, and it's a question we're getting from essentially all of our clients, right? It's just, why should I spend money on legal fees if I can deal with this administratively? The first answer to that is sort of what I said earlier: is don't gamble with $1 million+ right? Maybe if you have a lower claim, you'd be more willing to gamble with it. The second is that the government has said in a hearing that it only intends to refund those companies who have a judgment in front of the Court of International Trade. Now, that the court has not agreed with that. It may be that that's not lawful, but with the way things are going, it's better to sort of preserve your claim. It also may mean that you're first in line for the refunds. Also, not a guarantee, but if you have a judgment, generally those take first in front of everyone else. You're sort of like the first creditor, if you will. And so if there's only so much money that can be refunded because some of it is spent on, for example, setting up the administrative system, you want to be paid first. You don't want to be waiting for sort of the pennies that are going to be distributed at the end. The other reason is that we don't know how long the administrative route's going to take, so this might be faster. This is really important because we have a lot of clients whose customers have now come knocking at their door and saying, these tariffs are illegal. Where's my money? You should get your money, but I should really get my money because I'm the one who paid for it. And the problem with that is that if you don't seek sort of the legal recourse that may be available to you, and for whatever reason, your refunds are not paid, or other refunds are paid first and you're still waiting on yours, and customer, is knocking at your door, they may file against you to seek their refund, even though you haven't received it yet. And so this way you can tell customer that you have gone aggressively as possible, that your, either no other refunds have been paid, and so they can't be entitled to their refund yet. And so it really preserves and is a defense for you as the importer against customers who may have substantial tariff claims against you for refunds. So there's a number of reasons. There's, of course, no guarantees, but really going back to the gambling term, you really don't want to gamble here. And there's one judge ruling on every single case in the CIT, that's Judge Eaton. And so you're guaranteed continuity of rulings, which is a great thing here. Judge Eaton has already said that refunds are required. And so, it's not a sure bet, but it's as close as you can get in the courts to a sure bet.
Okay, that's good news. And so you mentioned thousands of cases and one judge and one court. So what's if you had to say, I know it's difficult to say now, but what's the estimated time frame for before we see the first judgment? You mentioned the FedEx case, for instance. What do you think roughly can be expected before we see the first decision being handed down?
Unfortunately, it's still entirely unknown. So what's happening, the sort of the disposition of these cases is that there is a leading case. That is Atmos filtration. That's the leading case in front of CIT. That's the case in which the government and the parties are actually meeting face-to-face in closed hearings with the judge. That's the case in which the judge is actually putting forth his orders on the issues. Every single other case that has been filed has been stayed. And that's a pause, essentially, on all the cases. They've used the exact same reasoning for all of the cases. And what the court is essentially doing is it's using this leading case to make the decisions for all the cases. Once we get to a place where the court feels comfortable with the CBP's updates as to what is happening with the administrative route. And, I believe that we're going to see a lift on those stays. I also believe that the court is going to put in place a system to sort of consolidate or make an ease of disposition on the cases so that it's not going through hundreds, right now 3,000, but maybe it'll be 30,000, right? Cases. And so it's not clear what that timeline is. The court originally said it wanted it, very quickly. And then it's actually walked that back and said, I'm satisfied with what the CBP is saying, and there is no current sort of timeline in place for the CBP. So as long as the judge is satisfied with what they're doing, the CBP can essentially take the time it needs, and then in the meantime, not much will happen on any other case.
Okay, makes sense. And you mentioned you don't want to gamble with €1 million refund. What is the minimum amount below which legal action risk becomes too costly? So you would not advise to take legal action and maybe only go down the administrative route?
Right now, just based on sort of our firm and our structure, we're advising clients really nothing below 300,000 to 500,000. Now, it may be that if you have a lower claim, there are firms that are willing to take that particular case for less. It's just not the way we want be able to provide individual personalized attention to each and every case and each and every client. And so I would say for a firm like ours where it's personalized, I wouldn't go much under $500,000. But there may be firms who are willing to go a bit lower.
And we should add that that applicants for the refund should also claim for interest in arrears. Am I right?
Absolutely. Yeah. Thank you for pointing that out. Yep.
Okay. So that's another factor why, I would rather be first in the line than wait for some time before I file my application, because I guess at the end, that will be a substantial amount also on top of the refunds. So, yeah.
Absolutely. And where is the government going to get additional money to pay for those unless it starts printing money, which, I don't think any of us really want here.
Yeah, absolutely. Okay. Well, Lisa, thanks. Maybe as a final question, and I'm sure we'll get back on this topic and get updates as things are moving quite fast. I was thinking deadlines. Is there a deadline by which companies or your clients should consider filing and start the lawsuit? Or yes, please.
Yeah, thank you for asking that question, because it's a very good question. There's no actual deadline, but the sooner the better. And the reason why is that there are claims entries that are about to be finally liquidated, meaning you may lose your opportunity to seek a refund on those. Actually, we have clients as early as next week that have claims coming up on final liquidation. And so we want to preserve those claims as quickly as possible. Now, you have 2 years from, I think, the entry to be able to really file the claim. But we're telling clients the earlier, the better. Get on file now, preserve your rights.
Okay. So thanks, Lisa. This has been very helpful, a very clear explanation of what's happening. And I'm sure things will keep changing, or we will have more information, especially as the first cases the leading case gets decided. So we'll be back in touch. And for the time being, thanks a lot. And I'll hopefully see you soon.
Thanks so much, Roberto.
Bye-bye.
Bye.